This is Boomer Time, a proactive podcast for baby boomers, about baby boomers, and for people taking care of baby boomers. If that sounds like you, then you're in the right place. I'm Nancy Kogar, an elder law attorney and aging advocate, and this podcast was made just for you. Remember, though, the things we discuss here are not intended to be legal advice, and no attorney-client relationship is established by this podcast. Hey there, this is Nancy Kogar, and this is Boomer Time. What do you think of that new music, huh? I figured I was going to pump it up a little bit. We're celebrating episode 20 today. All right. Thanks for sticking with us. I am just having such a great time, and I hope this is helpful to you. Let me know what you think of the new music, too. And to celebrate today, I'm going to kind of do something a little bit different. Today, we're going to try to tackle some frequently asked questions when it comes to estate planning or aging issues, elder law, just some things that come up often. These are questions I hear all the time. And some of them are questions that you've sent me as well. And, I encourage that, as there are lots of issues that come up and everyone's circumstances are always different. So I like hearing from you. And if you want to reach out, you can go to my website, nancykogar.com. So this is it. Today we are doing our first FAQs, for frequently asked questions. The first question, which I hear a lot of times, or I just hear a statement, I don't have enough that I need a will. What happens if you die without a will? Well, that's a darn good question. I wanted to first say that, believe it or not, over 50% of adults do not have a will. That's huge. And, I know it's not the top of everybody's list, but it is an important thing to take care of. And just the fact that half of us haven't done it, that should be a wake-up call, I think. Some of us also maybe have wills that aren't valid. That's another issue. Those do-it-yourself wills. I talked about that on episode 7, Do-It-Yourself Estate Planning Leads to Disaster. So you might want to listen to that and find out why you need someone who knows what they're doing and knows the law to take care of your estate planning. So with that aside, what happens if you don't have a will? Well, if you don't have a will, or you don't have a valid will, that's just like not having a will, you are going to be termed to have died intestate. And that means essentially that you died without a will, and the state's laws are going to control who gets your property. To me, that's reason enough to get a will that's valid, because you don't want the government telling you who gets what. And these laws vary from state to state. Tennessee is different than Georgia, and, Florida is different than Georgia. But typically, if you die intestate, there's a distribution that's made partially to your spouse and then to your children. And if you don't have children, it could go to other family members that survive you. I've had circumstances where I have had to go way up the family tree to find the ones that are going to inherit. You don't want that kind of situation. And you don't want the legislature to tell you how your estate should be distributed. So a will would help to alter that default from kicking in. In other words, you would be having permission to say who gets what of yours after you die. So I think that's reason enough to say you need a will. Problem is also, state law doesn't account for people that are not blood relation to you. And, I often see people, the whole reason they're doing their estate planning is because they don't want the people that are blood relation getting their stuff. So You can do that, but you got to be intentional about it. And if you don't, guess what? It's going to go right down the default to your blood family. That means that blended families, stepchildren, people in your family that you consider family that really aren't family, all of them are not going to inherit. And that's just probably not what you want. So, good question. Also, if you don't have a will and you don't do anything about titling or estate planning, you are setting yourself up to expose your estate to your creditors. And you say, well, I don't have any creditors. Well, you might when you die, especially if you're sick. So you have to take some steps to plan. Okay. All right. Well, the next natural question that I was asked was, what does a will do? And I kind of touched on that in the last answer, but I'll tell you, a will really in its most basic form is instructions for what happens to your stuff after you're done using it. Okay? Anything that isn't joint or doesn't have a payable on death designation, you need to provide some way for it to move forward when you're done with it. So that's what a will does. And it's got to be valid in order to enforce what you're asking. So even if you don't have a lot of stuff, it's important to have a will. All right, a lot of questions I get about, I'll get a lot of phone calls actually from people out there who say, hi, Nancy, I just need a simple will. And I'll say, okay, let's talk about that. I say, I'm not trying to tell you a bunch of stuff, but I gotta say, you need more than just a simple will. So that brings me to my next question. Why do I need powers of attorney? Trust me, you need powers of attorney. There are all kinds of powers of attorney, ones for healthcare and ones for financial, making decisions about you when you can't make those decisions. And you need to get these things done while you still can make decisions. If you don't, you're going to end up with a conservatorship and you're going to have a court telling your family or whoever is caring for you what you can and cannot do. So don't do that. I did an episode on this. Episode 10 was all about how you'd be SOL without a POA. And I really mean it. So one of the most important parts of estate planning is power of attorney. Powers of attorney vary from state to state, but if you get the right kind from someone who knows what they're doing, it's enforceable in all the different states. As we have a constitution here in the United States, and it's enforceable under the full faith and credit clause of the Constitution. We still have it. And so a power of attorney essentially gives one or more persons that you designate the power to act on your behalf when you're not able to communicate what you want in terms of your health care or in terms of paying your bills, applying for care, filing your taxes. It's widespread. But you really need to have this specifically written down in a power of attorney. You can limit the powers. Hey, if you don't want someone to have the power to sell your house, don't put it in there. But, most of the time it is very widespread, especially when it comes to what I do with aging adults, because there are things that come up all the time. And if they're not in the powers of attorney, you're not going to be able to do it. And, I tell people this all the time. So powers of attorney can be effective immediately, or they can be effective when you're incapacitated. And that's usually what I recommend, so that you make your decisions for as long as you're able to. And if something happens, guess what? You need someone you trust to make decisions for you. So that's why you need a power of attorney. You don't want someone who you don't trust, who is not good with money, making decisions about your money, right? So you have to be careful about who you pick. That's another thing. So you got to be intentional about this, right? The person in your power of attorney is going to be known as your agent or your attorney in fact, and they can take actions permitted within that document. As I said, there are healthcare power of attorneys. There are general durable power of attorneys. They all do different things. The healthcare power of attorney I wanted to touch on specifically, okay? Because it's a really simple document and it is so, so important. And most people do not have this. They think, hey, I'm young. I don't need a healthcare power of attorney. Well, what happens if you get into an accident? What happens if you get really sick? You know, a couple of years ago when we had COVID, do you know how many people I heard from the hospital who had family members who had generic end of life directives that said, do not hook me up to a respirator? And guess what? They were hooked up to a respirator because they had COVID. Well, I don't think that's what they meant as far as end of life care. But, you got into a debate with the hospital about that. That's why I say you've got to have these documents in place beforehand, okay? And it takes things like this. So my documents, I give some discretion to the agent because we don't know what the future holds when it comes to living wills. So, and everybody does this differently, but I'm just telling you what I decided to do after that COVID kind of experience. It's a practice, right? We're practicing law. So, but as I said, with healthcare power of attorneys, you have a constitutional right to deny medical coverage for yourself. Treatment, I should say, not coverage. Treatment. However, if you don't have a healthcare power of attorney and you don't have anybody authorized to make those decisions for you, you are going to receive treatment because the hospital needs to keep you alive. It also needs to be durable so that it does not lapse in the event that you become incapacitated. These are highly personal issues. People want to be able to have the right to direct their care, and they should. But if you don't take the time to get a healthcare power of attorney, you're not going to be able to do it when you need it, quite frankly. There's no better example of this than a case known as the Terri Schiavo case. Maybe you remember this. It was the Florida woman who was in a persistent vegetative state for 15 years. She finally died in 2005, but it wasn't after a huge legal battle between her husband and her parents about whether she should be disconnected from the medical machinery that was keeping her alive. There's a new documentary on this that's out on Peacock, and I think I'm going to watch this. I haven't seen it yet, but it talks about all of these issues, and it just, it involved everything: legal, social, spiritual, medical, ethical, every aspect of that right to die debate. It was painful to watch that, and her husband, Michael, wanted to disconnect her from the feeding tube. But meanwhile, her parents, Robert and Mary Schindler, they challenged her husband in court for years to keep their daughter alive. Years. Bottom line, you want to have some enforceable, trusted directives in place. If and when you face an emergency in your life, you need to have those powers of attorney in place, and they need to be valid and effective and specific. How's that for an answer, huh? Okay, so, and I touched on this before. There are all kinds of other directives. There's living wills, advanced healthcare directives. Of course, people are living longer than before. So, as we grow older, of course, we're going to experience health challenges. So Get these things done. You find yourself in a position where, someone needs to know how you want to be treated in a variety of medical situations. This is the way to do it. This is especially true, of course, at the end of our lives. I'm sure we've all thought about that. How do you want to be treated or not treated when you're at the end of your life? I mean, there may not be a more important question than that. It's certainly in the top 3. That's what these documents do, okay? And as you can see, people may disagree if you don't articulate it, and it could lead to a big legal battle. And they may not even have the authority to make the decisions for you if you don't have the right documentation in place. All kinds of states vary, so that's why it's important to have these documents in place. So we're going to take a break, and when we come back, I'm going to continue to answer some of these frequently asked questions on this 20th woohoo episode of Boomer Time. Be right back. Welcome back to Boomer Time. This is Nancy Kogar, and this is our 20th episode. And we are talking about frequently asked questions today. So before the break, we were talking about wills and powers of attorney, and I hope that helps for you to see how important those things are. Here's another question, which even sometimes lawyers ask me, believe it or not. What is elder law? Right? What is elder law? Well, elder law encompasses a lot of different things, but it has an emphasis on issues affecting aging seniors and the legal rights and protections for you as you get older. So, someone that's an estate planner may not have a focus on elder law, but then you have an estate planner that does have a focus on elder law. So you can see how that might change. Elder law covers a wide range of issues, as I said. And I deal with things from long-term care planning options to estate planning, to powers of attorney, to issues involving vulnerable adults, scams, all kinds of things. And nursing home abuse can come into that. I don't particularly do that, but that can be encompassed into that practice area. So that's what elder law is. Good question. Here's another question, and I answer this one delicately, okay? Are handwritten wills enforceable in Tennessee? Quick answer is yes, but yes with some key points, okay? Handwritten wills are also known as holographic wills. And that is a type of last will and testament that is entirely, okay, in the handwriting of the person making the will, who's known as a testator. So in Tennessee, holographic wills are recognized as legally valid, but they come with some specific requirements and considerations. Okay, like I said before, it has to be entirely in the testator's own handwriting. All right? That's important because form wills are not valid. So a fill-in-the-blank will that you put in your handwriting in the little blanks, that's not valid. That's not considered a holographic will. This has to be entirely in their handwriting. Doesn't have to be long. Could be one little paragraph. But it has to be in their handwriting. It also needs to be signed by the testator. That's important. So it can't just be a list. It has to be signed and in the handwriting. In order for it to be valid, that will maker has to be 18 years or older and have the capacity to make a will. We'll talk more on that in a minute. And as I said, it has to be in the handwriting. You can't write it on someone else's behalf. And it must be proven by 2 witnesses who recognize the handwriting. That is key. Okay? These witnesses don't need to be present during the making of that handwritten will, but you bet your dollar they're going to have to come in and testify to the court that that's the handwriting of the testator when it's presented to be probated. There's the issue. This is ripe for litigation. I will tell you. I've had some cases like this, and to me, there are circumstances where this comes into play, and it's important that that I think that the state recognizes the right of someone making a will to be able to make it in their own handwriting. You may not be able to afford it, or maybe there's a circumstance where it needs to be done quickly. But remember, you have to have the capacity, and your handwriting needs to be recognized by at least 2 people when it gets to be time. And like I said, there are all kinds of problematic issues with that. If you can opt for a formal will, I would say do it. Okay? And make sure you go to somebody that knows how to do it, because there are formality requirements with wills too. Don't do it yourself. That's what I always say. When do brain surgery on yourself, right? Don't do it yourself. All right. What is probate? And with this, what are letters testamentary? I get all kinds of people call me and they say, my dad died and I went to the bank to try to close out his account, and the bank told me they wouldn't talk to me until I had letters testamentary. What are letters testamentary? Well, letters testamentary are something you get on probate. What is probate? Probate is court-supervised administration of an individual's assets after they die. It can be done either by a will, or like I said before, if you don't have a will, then the state law controls. Either way, if you don't have a direction for where your assets need to go, and your will provides what happens to them, well, we're going to need to put that in court in order for it to be effective. So whoever you appoint as the executor or the personal representative, they are going to be, hopefully, if it goes well, they're going to be issued letters testamentary. And that is what gives them the authority to act on behalf of the estate. So once they have those, then they can go back to the bank and get the account closed for the estate. And you're putting that in an estate account at that point. So the purpose of probate is to safeguard the rights of heirs and beneficiaries and creditors as well, because that's where they file their claims. So that is the reason for probate. Here's an important consideration. You might want to do all you can to avoid probate. And if that's you, because it costs a lot of money, and you're exposing yourself to your creditors. So talk with a lawyer about that. Give me a call. I can help you with that. But, see a lawyer, an estate planning lawyer. Okay, so speaking of which, what are the alternatives to probate? I kind of mentioned some of that before, but it's something as simple as titling, quite frankly. Joint assets in the state of Tennessee do not require probate, because if something's joint, it has rights of survivorship, which means that when one owner dies, it passes to the remaining owner. So you don't need probate for that. See, it's got a direction where it moves. Also, if you look at payable on death, transfer on death, beneficiary designations, those are an excellent way to avoid probate. And you can do that on bank accounts. You can do that on retirement accounts. I always recommend have contingent beneficiaries because I've had cases where, say, a parent put a child, not expecting that the child would pass away. The child passed away, and the beneficiary designation was never changed. So if you don't have a beneficiary designation, it's going to go to your state and to probate. Here's another way you might avoid probate is with a trust. There are all kinds of different trusts. Some are more complicated than others. But if you have a trust, the assets that get titled into the trust do not need to go through probate. And that can be a really effective means and alternative for people because there's no waiting. There's no court administration. There's no court supervision with a trust most often. So that's a good kind of summary of what alternatives might be. I did want to touch on one other thing because I think this is important. Someone asked me, what happens if I lose my will or my heirs can't find it? This is an excellent question. In the state of Tennessee, you need to present your original will to the court to be probated. Unfortunately, under the law, there is a presumption if you cannot find the original that it's been revoked. That means that it's assumed that you destroyed it. And guess what? That means that you died without a will. So you want to preserve your original. Also, heirs can't find it. Let them know where it is. Leave some word about where we can find it. Trust me, I see emails all the time from attorneys here in town looking for wills. So this is a huge issue. So those were some pretty good questions, I think. And I really enjoy answering those questions. If you've got questions, feel free to send me a note. Ask me the question. Might make a good next show. I'm going to do this again. This is our first FAQ show, but we're going to have more. And I really want to know what you're wondering about. If you are, chances are somebody else is. So thank you so much for listening today. As I said, I do like to end with some encouragement. And I just encourage you in thinking about all these things. It can seem overwhelming, but don't let it overwhelm you. Just find somebody that you connect with and talk through some of these issues and just really spend some time, intentional time thinking about it because it's important. Like I said, it could be life or death for you. So it deserves some attention. So with that, I just invite you to have a wonderful remainder of your week. And if you need more information about these things and resources, of course, as I always say, you can go to my website, nancykogar.com. And keep listening, folks. If you like the show, like it, follow it, even share it with a friend. We want to get the word out. So keep supporting Boomer Time. I want this to be a resource for you that you can rely on and become empowered and learn more about these issues. So that is my intent here. So thank you for listening today. And let me know what you think of the new music. I think it's jazzy. I wanted something more upbeat. So yeah. We'll see you next week, okay? Have a good week. Bye.